Welcome to our webinar today on the subject of support and information businesses may need about COVID-19 and vaccinations. And it will be presented by the great team at Gibson Sheat Lawyers. I'm Patrick McKibbin and I'm the new CEO of the Hutt Valley Chamber of Commerce. We're really pleased to welcome today Mike Gould and Nikki Farrell from the Gibson Sheat Lawyers team. Gibson Sheat are a platinum partner of the Hutt Valley Chamber of Commerce, and they have a long history in the Hutt Valley. They have offices in Lower Hutt, Wellington and Masterton. Their wider team, have a wide knowledge of experience across all areas of law, including property, personal, litigation, rural and business. They offer personalised practical solutions, and they pride themselves in taking a personalised approach to each and every client. Today, I'm really pleased to welcome Mike Gould. Mike is a partner and head of the employment law team at Gibson Sheat. He joined them in 1985 and became a partner in 1987. He has extensive experience in employment law, general commercial law and trusts, and he is the head of the Gibson Sheat employment law team. Mike is joined by Nikki Farrell, a senior solicitor at Gibson Sheat. Nikki has recently returned from 3 years in London, where she worked for the UK government legal department, defending judicial review applications. She previously worked in New Zealand for the government, focusing on employment and privacy law. No doubt she is very happy to be back in NZ and working with the Gibson Sheat team in the Hutt Valley. I'm now going to hand over to the Gibson Sheat team, to Mike and Nikki, who will take you through their views of the support and information businesses might need about COVID-19 and vaccinations. So I'll hand over to you, Mike and Nikki.
Thank you, Patrick, and good afternoon, everyone. There are at least 6 pieces of legislation that are relevant when we're looking at COVID and vaccination in the workplace. I'm going to look at 3 of them, and then Nikki's going to look at the other 3. The first important piece of legislation, of course, is the Health and Safety at Work Act. And that puts on employers a primary duty of care, and I'll quote it exactly: the duty is to ensure, so far as is reasonably practicable, the health and safety of workers while at work. And then it gives employers some guidance when looking at whether an action is reasonably practicable, because that's the key. And it lists the factors that an employer should look at when deciding whether a proposed action is reasonably practicable. And there's 5 issues that the employers should be looking at. The first is the likelihood of the risk or the hazard occurring. Second is, if it does occur, how much harm is going to result. Thirdly, are there known ways of eliminating the hazard? Fourthly, are there suitable ways to minimize it? And fifthly, does it going to cost a lot? What are the costs associated? So if an employer was looking at his or her workplace and analysing whether or not COVID-19 was a risk that needed to be eliminated or minimised, I think many employers would come to the view that requiring employees to be vaccinated is clearly reasonable and practicable. Obviously, there's a high likelihood of that disease reaching our towns. We know the serious harm that might result. We know that vaccination is available and cheap to minimise the risk. So an assessment of that might lead an employer to say, I think it's perfectly reasonable for me to require my staff to be vaccinated. But the responsibility in the Act is not limited just to the employer. So there are some obligations on employees. And the employee must take reasonable care for his or her own health and safety, and that his or her own actions don't adversely affect the health and safety of others. So it's a two-way street. The employer's got to do what's reasonable to keep workers safe and healthy, but so do employees. And there's another part of the Health and Safety Act which requires workers to comply with reasonable instructions given by the employer and cooperate with reasonable policies relating to health and safety. So that's the main piece of legislation that we need to look at. Secondly, possibly relevant is the Human Rights Act. That act makes treatment different treatment based on somebody being disabled unlawful. But there's an exception to that unlawfulness, and that's where the person is working in an environment such that there is a risk of infecting others with an illness, and it's not reasonable to take that risk. So it may be possible to lawfully discriminate against somebody with COVID because of the risk of infecting others in the workplace. And the third piece of legislation I want to talk about is the Employment Relations Act, and it's a very simple part of the Act. So the main requirement under the Employment Relations Act, as you probably know, is the duty of good faith. And the duty of good faith says, and I quote, "The parties to an employment relationship must be responsive and communicative." So if an employer is asking employee questions about health and safety, arguably the employee has a legal duty to be responsive to those. Nikki's now going to talk about some of the other legislation.
Kia ora koutou katoa. Another piece of legislation to consider is the New Zealand Bill of Rights Act, which sets out the rights and fundamental freedoms of New Zealanders. The relevant section is Section 11, which gives everyone the right to refuse to undergo any medical treatment. Medical treatment would include receiving a vaccination. However, this right is subject to justifiable limitations. Next, we're going to talk about the Privacy Act. Whenever you handle personal information, you must follow the rules and privacy principles in the Privacy Act. This means you can't collect personal information, including vaccination status, just for the sake of it. Collection of personal information must be lawful, fair, and not unreasonably intrusive. You must have a clear purpose of why you're collecting the information, and you must tell the person the reason that you're collecting that information. The easiest way to obtain that information is directly from the individual themselves with their consent. Next, we're going to consider the public health order. There are certain roles that the government has decided require compulsory vaccination. A public health order makes it compulsory for people in MIQ and most high-risk border roles to be vaccinated. We're expecting the government to expand that order to cover more roles that may include aged care workers, healthcare workers, and teachers, like they have done in other countries. We recommend that you watch the space. The next thing to talk about is the health and safety risk assessment. There is a view that if a company thinks that there are specific roles where workers need to be vaccinated, then they should complete a health and safety risk assessment. The risk assessment must be on the role and the work being done rather than on the individual performing the role. WorkSafe have provided some questions of what risk factors to consider. You can find these on their website, but we thought we would bring them out to you as well. The first thing to consider is how many people does the employee carrying out that work come into contact with? How easy is it to identify the people who that employee has come into contact with? How close is the employee carrying out the tasks in proximity to others? How long does the work require the employee to be in that proximity to other people? Does the work involve regular interaction with people considered at a higher risk of severe illness from COVID-19, such as people with underlying health conditions? What is the risk of COVID-19 infection and transmission in the work environment when compared to the risk outside work? And finally, will the work continue to involve regular interaction with unknown people if the region is at a higher alert level? You may have heard about the recent Employment Relations Authority decision about a customs worker. She was a border protection officer in a maritime port facility. The government introduced rules requiring frontline border workers to be vaccinated. She said she didn't want to be vaccinated and her employment was terminated. She brought a claim for unjustified dismissal and sought reinstatement. Customs conducted a health and safety risk assessment of the role and determined that yes, it did require vaccination as she was at risk of coming into contact with the virus. Customs offered to find her alternative role, but if that wasn't possible, then her employment would be terminated. Her application for reinstatement was dismissed by the authority, and her challenge of that decision in the High Court was also dismissed. Justice Peter Churchman said the court's task in this case was to balance the benefit of the vaccine and the risk of being unvaccinated against any discrimination in relation to those affected. Her unjustified dismissal case is still to be heard. In another case, a claim was brought against the Civil Aviation Authority by 4 employees who were dismissed for refusing the vaccine when there was a public health order in place. Their application for reinstatement was dismissed, and their claim against the unjustified dismissal claim is still to be heard.
So that's the legislation and the current case law that we have around vaccination in the workplace. In the context of those laws, what can an employer say and do regarding COVID-19 and vaccination of employees? Well, firstly, we suggest it's not unlawful for an employer to ask employees about their vaccination status. The employer could reasonably consider that in the midst of a dangerous epidemic, that information is needed in order to assess the safety of the workplace. So on that basis, we could say that the personal information of the employee that the employer is seeking is being sought for a lawful purpose in connection with the functioning of the workplace, and so it's not unlawful or in breach of the Privacy Act. But then does the employee have to answer that question? Again, the employer might reasonably take the view that the duty of good faith requires an employee to give an answer, thereby being responsive and communicative. And you'll remember that that's an obligation of good faith under the Employment Relations Act. And to not be responsive or to be uncommunicative would be a breach of that. Then on the contrary, you might get an employee in a workplace, particularly outside Auckland or Waikato, say in Invercargill, who might argue, well, look, you don't need that information. There's no COVID in our town, it's miles away, and your question is an overreach and an unnecessary, unreasonable intrusion into my personal information. So the employer faced with that employee might come back and say, well, hang on, we're being overwhelmed with scientific medical information that's telling us COVID is going to be in our town by Christmas time. So it's perfectly reasonable for me to take action now to keep my workplace safe from that disease. We're being told endlessly and daily that vaccination is the key to protection against that disease. So if the employer maintains the view that the collection of that personal information, i.e. vaccination status, is valid, then there are still some protections for the employee. Under the Privacy Act, the collection of that information has to be collected with the employee's consent, and there is one exception to it, to the disclosure requirements. In other words, the employee can't necessarily disclose to others what the answer is, but an exception is where it's necessary to prevent or lessen a threat to public health. Now, that may become an issue as this disease grows. The next question I look at is whether employers can amend existing staff employment agreements. So the general rule is that an employment agreement can only be varied by agreement between the parties. So the answer is no. However, following proper consultation, an employer is able to introduce policies into the workplace. Now, these are not technically part of the employment agreement and don't require the agreement of the employees. So arguably, a policy requiring employees to disclose their vaccination status is not a variation of the employment agreement. And many employment agreements, most that we draft, contain a clause saying, apart from this employment agreement, you agree to be bound by the terms and conditions of any policies we introduce. It might also be said to be a reasonable instruction under the Health and Safety at Work Act. And you'll recall that Act requires employees to cooperate with any reasonable policy of the employer relating to health and safety. Nikki.
The next question to consider is, what can an employer ask prospective employees? Well, you can ask them anything as long as it's not discriminatory. You could ask them if they're vaccinated or if they are in the process of getting vaccinated. So what can be included in the employment agreement for new employees? A clause can be included in the employment agreement for new employees that states that they are required to be vaccinated and that they need to show you proof.
Thanks, Nikki. We're getting to the sharp end of these questions now. So what action can an employer lawfully take in regard to an employee who declines to disclose vaccination status or states that they're unwilling to get vaccinated. So the answer to that for the employees covered by the public health orders that Nikki talked about is quite straightforward. So if following consultation there are no alternative positions, then termination of employment, sadly, would be justified. Now, I suspect most of you won't have the safety of a public health order covering your workplace, and therefore you have to fall back on the Health and Safety at Work Act. And I'll remind you of the duty that the employer's duty is to ensure, as far as reasonably practicable, the health and safety of workers. One of the subsections goes on to say that the employer must ensure, as so far as reasonably practicable, quote, a work environment that is without risk to health and safety. Now, given all of the scientific and medical literature and publications we're seeing and the very strong push by government for vaccination, we consider that it would not be unlawful for an employer to assess the risk of COVID-19 as being too high to ignore, and in order to protect the work environment, to require employees who work in close proximity with each other or others to have the vaccination. If we accept that view, what does an employer do when an employee declines to be vaccinated? Well, if there are no alternative positions in the workplace that can be safely undertaken by an unvaccinated employee, for example, working from home, then following full and proper consultation with that employee, we suggest that termination of employment could be a justifiable action. Now, we have to caveat that advice. The various statutes and laws around these issues are sometimes in conflict with each other. The law of the Privacy Act may come into conflict with the employer's right to ask questions of an employee under the Health and Safety at Work Act. And of course, COVID-19 probably wasn't in anybody's contemplation at the time these acts were written. So while our view is that a strong case can be made for an employer to be permitted to require employees to be vaccinated, there is contrary opinion out there. And if you get two lawyers in a room, you end up, of course, with three opinions. So for definitive answers, we really need legislation or the courts to give us judgment on actual cases. So now we are happy to take any questions, and I think Patrick's going to come on for that.
Thank you, Mike and Nikki. That was a very comprehensive summary for us and those people watching. I guess the first question I have is thinking about individuals or teams, particularly these conversations in team meetings versus individual discussions. What should an employer consider there to ensure they're safe and their employees are safe in those situations?
I guess the starting point for us is that those should initially be private conversations between the employer and the employees. And I know there are workplaces now who are sending out surveys asking staff members to confirm their vaccination status. Many of those surveys are saying this information won't be shared with anyone else, and of course it shouldn't be. But they're also often saying if you decline to answer, then the employer is going to assume that you are not vaccinated. So I don't believe it's a discussion to be had in the open and team environments. It may be the information could be sought in an open manner via email or so forth, but it's not really information that should be shared with other employees. Now, having said that, if an employer treats an employee differently because that employee has got COVID or isn't vaccinated, it's going to become quite obvious to the other people in the workplace that there is a difference there.
We have a question from one of our audience, which is great. Thank you, Gail. Interested in what is an employer's obligation if an employee has an adverse reaction to the vaccine?
Does Does the questioner mean whether the employee becomes sick because of the vaccine?
I guess so. Yes. Probably as sick. Let's explore. Is sick and has time off as a result of the vaccine.
Well, that would be covered by normal sick leave. One of the tricky questions around here is if an employee is saying, I can't have the vaccine because I will have an adverse reaction to it. That's unfortunate for that employee, but for the safety of the workplace as a whole, there's not much difference, if any, between an employee who, for medical reasons, can't have the vaccine and an employee who, for philosophical or other reasons, won't have the vaccine. The employer is faced with the same issue of keeping the workplace safe, notwithstanding the very genuine reasons somebody might have to not be vaccinated.
Great. So I guess a further question that I'm interested to explore is the safety aspect of these conversations occurring in the workplace. I think as more people become vaccinated, there is likely to be pressure from employees or an employer or even their customers. What do you recommend an employer considers in terms of prevention of a situation where an employee feels like they've been victimized in some way or other?
Well, if there was victimization of that employee, then it would be like any other victimization. It would be unlawful and a breach by the victimizers of their duty of good faith to the employer. And you'd be arguably in the bullying and harassment area as well, and the harassed employee would have a claim against the employer. So I guess the answer is the employer would have to stamp on that kind of conduct immediately and take even disciplinary action against people who were overtly being prejudiced or making comments about the unvaccinated person or the person with COVID.
Thanks, Mike. And I really just also wanted to explore the situation for employers that have customers that are requiring their staff, or customers that are saying they only want to see staff that are vaccinated. What would be your advice in those situations to an employer who's, both from a customer perspective, from their dealings with their customers, but also from an employee perspective in those situations?
So that's a difficult one because our customers are entitled to say whether they'll deal with us or not and tell us on what terms and conditions they will deal with us. But if our customers' requirements are too stringent, we might have to forego the custom of that customer. So at the moment, as we speak, if one of our clients came in and said, well, I'll only deal with you if you've been vaccinated, I don't know how we would react, but we probably would not be free to tell the customer who or who isn't vaccinated. The other side of that coin is this. There have been cases where customers have said to, for example, carriers, you can't bring that truck driver onto my premises. There was a specific case in the employment court where for various reasons, the company for which the carrier worked would not allow that driver onto its workplace. And that was the only contract the carrier had for that specific company. So it was validly entitled to make that employee redundant because the customer would not allow the driver on their workplace. So unfortunately, and perhaps not even to the fault of the driver, he was made redundant in circumstances that were driven by the customer. So we're not yet in a position to know how that's going to happen, but we can anticipate that our clients, customers are going to ask us, is the person I'm dealing with vaccinated? And we will have to try and get that information from our staff who are customer facing. And if enough of our customers require that, At the end of the day, it may be that it's a condition of employment that you are vaccinated.
Okay, so we've got one final question before we finish, which is what would the process to follow be if an employee does refuse the vaccine? Is it are we talking about a normal exit process for a person from an organisation? And if it's about health and safety and keeping people safe, should you make them work out their notice?
Well, the question presupposes that the employer has decided that it's a health and safety risk not to have someone vaccinated and has required all employees to be vaccinated. And the questioner is asking, if this one person refuses to be vaccinated, what do you do? Well, the employment law, as we found out last year, hasn't changed under COVID. So there would need to be consultation with that staff member, advice, look, this is why we need you to be vaccinated. Can you be vaccinated? Will you be vaccinated? Can you take some time to think about it? We will look around for whether there's alternative roles for you, for example, working from home. But if there are no alternative roles, then sadly, you can't keep working for us. Now, the time frame would be, generally you need a week or two at least of conversations with that employee to try and explore where their view comes from and whether there are any alternatives. But at the end of the day, if there are none and it's a health and safety issue, termination could take place. Now, in terms of working out notice, most employment agreements provide that the employer can pay in lieu of notice. And arguably, it would be the safe thing to do once you'd been through that consultation process to not require the employee to work out that notice period.
Great. Well, look, that's the final question. Thanks, Mike and Nikki. And for our viewers, thank you for tuning in today. Look, I really just want to say a huge thank you to Mike and Nikki from Gibson Sheat Lawyers for their time today and sharing your knowledge and advice. And thank you for those people out there that have taken the time to listen and ask questions. The webinar will be saved and live on the on the Hutt Valley Chamber of Commerce website for you to view again if you need further clarification. And we'll continue to bring interesting and useful webinars like this through the next few months to help you as employers to be kept informed and advised on important subjects. So thank you for your time today, and wish you a good rest of the day and a good rest of the week. Thank you.